everyone, and welcome to North Alabama Law Review presented by Johnston and Weston. We're glad you're joining us today. Today we have two of our managing partners here today. We have Christopher Weston, who has extensive experience in contracts and Social Security disability. And we also have Miss Allison Moody, who specializes in personal injury and also insurance claims. Thank you for joining us today, guys.
Yep, thank you for having us.
Today's trending topic is about employee contracts and non-compete clauses. As Huntsville expands and grows, we have lots of people moving in here for the tech industry and the government contracts. So we would like to ask our panel here on their legal guidance on what we should be aware of when it comes to these non-compete clauses, severance rights, and also intellectual property. Guys, could you give us some feedback on what you recommend for our viewers to keep in mind?
Yes, absolutely. Allison, if you don't mind, I'm going to jump in on this one because this is my bread and butter. So I will tell you that for those of you who've been watching this show for the past several episodes, you'll know what my first piece of advice is. Read your contract. Read it extensively. Read it several times before you sign it. A lot of times what we'll find is people will walk into just an absolutely wonderful job, and they'll want to sign on the dotted line. They'll want to get it done quick. Sometimes they'll even be under time pressure from their prospective employer. Rule number one, take your time. Never rush into a contract like this. You need every single time to read it and make sure that you understand every line in that contract. And if you run into anything that you are uncertain on, again, that's usually my second piece of advice is consult with a lawyer. Again, especially at our firm, we do not ever have any kind of high pressure sales job to bring you in on a case or to turn something down, but a little bit of time on the front end, a minor bit of expense on the front end can save you a ton, just sometimes years worth of hardship and cost and hassle on the back end if something happens to go wrong. Because that's ultimately what a contract is. It's what happens if things go wrong, okay? Or what will happen during the course of your relationship with somebody. In the term of partnerships, it's more like a marriage a lot of times. In the terms of an employment contract, it is a little different because Alabama is an at-will employment state. What that means is that an employer can fire you for just about any reason or no reason at all. Now, of course, there are some limits on that, and we may have this for another topic. Things like you are not allowed to fire someone due to their race, sexual orientation, their national origin, their religious preference. There are obviously civil rights obligations and duties and limits on why you can terminate somebody. But outside of those more federal Title VII claims, that Alabama is an at-will employment state. And so what that means is that if you're entering into an employment contract, you are entering into it without any requirement to do so. Yes, you may not get the job that you want, but you are not obligated or bound to enter into any kind of employment contract. So when you're looking at these, the way that Alabama views these is that this is a free will contract. Again, you're not obligated to enter into it. And so what ends up happening is that these are usually upheld. Now, there are some limits I'm about to go into, but if you do not know what you are entering into, you can bind yourself for months, years, or sometimes a lifetime, and you can lose significant rights. One of those rights is rights to intellectual property that you may be developing. Look very, very carefully at what the contract calls confidential information, or trade secrets, or who owns intellectual property rights or copyrights, or any type of invention, because those contract terms are usually going to be upheld. So if you go into a company because they want to buy something or employ you because you are developing something and you own IP rights or you're about to own IP rights once you finish whatever it is you are inventing, you can run into a serious, serious problem if the terms of that contract state that they own everything to do with that invention or that idea that, you may only be at that company for 3 months. And so you need to look at duration. You need to look at what you're giving up. You need to look at what you're being compensated for. A lot of times we find that people will look at something and look at what their compensation is going to be during the term of the contract, and they don't always look at what they're going to end up losing at the end of it. There are also non-competition and non-solicit clauses in contracts. Now, those are limited. You know, usually the rule of thumb is about 18 months to prohibit you from either not soliciting or not competing in a given geographical area. So these do have to be more limited, provided that it is interpreted under Alabama law. So if any of you out there have seen any of our legal minutes, you'll see I spoke about forum selection clauses. What a forum selection clause is a clause that says what the jurisdiction is going to be if something goes wrong and it ends up going to any form of litigation. And along with that forum selection clause, they can choose, provided you agree to it, what laws are going to apply. I mean, you can have a contract in Alabama that says it will be litigated in Delaware under California law. Now, I've never seen one quite that egregious, but you get the overall point that you can have a contract that has disparate laws even if nothing occurred in that other state, okay? And so you need to know if something goes wrong, where am I going to have to press this? Am I going to have an arbitration clause, meaning you don't get a jury trial, you have to take it under certain arbitration rules. You'll still get more of an informal truncated trial, but you're not going to have a jury, or you're not going to have certain rules of evidence, or you're not going to have certain evidence allowed in. You need to be looking at, is there an arbitration clause? Is there a non-compete? Is there a non-solicitation? What am I getting paid? How long am I going to be working there? What are they expecting me to do? And, you know, again, really look deeply at the confidential information section and trade secret section. That is one of the most paramount things, because under certain contracts, you could be working there, I don't know, putting together cell phones and working something privately at home on your own time. Now, you could litigate that, you could argue it, but if you're using anything from that company or any idea or anything you learn there, you can end up losing your entire invention depending on the terms of that agreement. And so again, if you're ever thinking of entering into an employment contract and you are not well versed in them, or you've not been entering into them for a long time, or there is literally any line in that agreement that you don't understand, you need to consult with somebody. You need to at least know what you're walking into. And that would be my main advice in dealing with any kind of employment contract, because they are very much seen as optional. So if you enter into one, you had no coercion to do so, because again, Alabama is an at-will employment state that they can hire or fire as they see fit. And so if you're entering into a contract, you're choosing to do so under the eyes of the law. And because of that free contract, even some of the harshest terms can be enforceable. But the good news is that if you get someone who knows what they're doing and how to interpret these, and there's something that's off, a lot of times an employer will be willing to make at least slight amendments to your employment contract to make it more palatable for you. And again, it comes down to leverage. It's something I teach all my associates, is the number one rule in contract is leverage, okay? So depending on what you're bringing to the table, but you need to know what you're dealing with, you need to know what you're walking into, and you need to have someone negotiate that contract if necessary. That also goes into severance packages, severance contracts, severance agreements. A lot of times have all of those same types of terms. And so they'll offer you some money, which is good, as a severance, but you need to be very careful about what you're signing. And I mean, that is something that goes across all of law. And I think that's, the main things I like to cover there. But again, have somebody review your contract if you are literally uncertain about any aspect of it. Allison, what do you think?
I agree with all of that. One thing that you touched on was the non-disclosure, non-compete agreements. Those apply to anybody but professionals. So if you are a dentist, a lawyer, a doctor, public policy requires it. We can't enforce those against any professional because of the need for the greater public good for those. But if you are, not one of those qualified professionals that typically requires additional schooling or licenses or certifications, that's when you're going to really be at risk for these non-compete agreements affecting you.
Yeah, that's absolutely right, and thank you for catching that. And again, that's why it's so important to make sure you have more than one person reading your contract if there is anything that you're uncertain about. It behooves you to save years worth of problem with just a little bit of knowledge up front. Thank you, Allison. Yeah.
Great information, guys. So it sounds like it's better to prepare and protect yourself on the front end to avoid any difficulties on the back end. Does that sound about right?
Oh yeah, this is one of those times where asking for forgiveness instead of permission is not the way to go. It is absolutely not the way to go.
Gotcha. Especially when we work with the arsenal here in Huntsville, all the tech industries. I imagine that this is going to be very informative for a lot of our viewers that are moving into the area, especially.
And I'm going to throw one more thing there, especially as we get into the realm of AI.
Yes.
Because you're going to have lots and lots of questions if you're using an AI that's on an internal system. Like we've had that, topic before that's on an internal system and you use any of it. Well, are you using a company tool to help you develop something? Mm-hmm. There is going to be an entire area of law that opens up, I believe, eventually dealing with, what constitutes an independent invention, what does not, what is a trade secret. Because, a company may call it a trade secret, but if it was generated elsewhere, well, how much of their other confidential information was actually used to develop said trade secret? It is highly nuanced. It's one of the reasons I love contracts is it is one of the most highly nuanced areas of law. The way I explain it to people is you have to think of it like a Rubik's Cube. You're trying to line up the sides and see how each provision interplays with every other provision. Because if you get something off, you cannot have the picture for your future that you wanted. And that is extremely important. Love doing it.
So thank goodness we have attorneys to help protect us, to look over those contracts for us.
Or break them, Shauna.
True. Well, today we're going to jump into some questions from our viewers. Our first question is, how can I protect my small business if a customer is threatening to sue me for something that is not my fault? Allison, you want to go first on this one?
I'm going first?
You're going, all right.
Okay. I guess I'll go first. So on this one is, it really depends on what you're dealing with. The knee-jerk reaction is always get a lawyer. If someone's threatening lawsuit, again, know your rights, especially if they're threatening suit, because that deals with procedure, filings, sometimes prerequisites to filing that they would have to do, like an attempt to mitigate. There are a lot of different things out there when someone is threatening lawsuit that, again, consult with a lawyer. Not trying to bring up any type of sale of services. We do that, but see somebody, okay? Especially if you're being threatened with lawsuit. But that being said, is the general advice is you're dealing with the public. And so you're going to run into people who are just aggravated. You are going to run into people who may be threatening lawsuit, but it's just patently ridiculous. And so you can use your discretion and should to a certain extent. If you're selling hot dogs and someone got a bad topping and they threaten to sue you, yeah, you may not necessarily need a lawyer for that one. But then again, if they choke, maybe you do, or they have an allergic reaction, maybe you do. And so it comes back to that general piece of advice I've been giving for several episodes now is if you run into something you don't understand, a word, a term, a threat, a situation, anytime you run into something in business that you don't understand, it's better to get advice. It's always better to get advice. Again, I currently run a law firm. I have an entire group of people that I come to. I have an entire management team so that I make certain that, it's not just my opinion when I walk in on something. I mean, you don't want to do that. We have a rule in business or in any type of industry. over specialization breeds weakness in any system, okay? You need to have a different set of eyes on it, especially if it was anything, severe, traumatizing to watch, or if you're feeling under threat in your business that you have, built up, or that you are running, or that you have, invested years of your life into. You may be too close to the problem. It may seem bigger than it actually is, or smaller than the risk actually necessitates, okay? And so, again, come to a lawyer if there's anything that you're uncertain of. But some of the basic ways that you can protect your business is signage, if there's, a hazard that you know about, taking basic precautions to make certain that no one can really get hurt in a way that wouldn't take some serious effort on their part. Again, slippery floors, unbolted shelves. On the legal side of it, having E&O insurance, errors and omissions insurance in your business. Having a liability assessment done, having somebody come in and do an assessment on what the risks are. Now, if something does go wrong and someone is threatening suit, fixing the problem usually, except for under extraordinarily limited circumstances that I've never actually seen occur, they can't use that against you in court. So if something goes wrong and it is because of a defect, you can fix that defect without worrying that that's going to come back as, proof of fault, okay? And so it's a very good idea that if you do find a hazard at any point, fix it. But if someone is threatening to sue your business, be mindful of what you say. And the reason I say that is Alabama is a one-party recording state, okay, or one-party consent state for recording. And what that means is that if one party to the conversation decides to record it, they're allowed to, and it's admissible, okay? And so, when something first happens and you're caught off guard and you're in shock and it's in the middle of your busy day, it's really easy to say something off the cuff that, you don't really mean it the way that it sounded, but now it's on recording forever. I'm sure we've all seen TikTok and social media and, circumstances where sometimes the person was in the right, sometimes the person was in the wrong, but now it's out there for all of posterity, okay? So insurance, having knowledge, potentially having a general counsel, which is something we can talk about later. But businesses of a certain size may want to consider a GC, again, a general counsel. And as far as a lawsuit goes, is take every document you get about it very, very seriously, okay? That seems to be, almost a no-brainer, almost something that would be a gimme. Oh, I got something from the court, I need to take it seriously. Those deadlines can run quicker than you think. Okay, now there are ways where you can ask for forgiveness for missing a deadline, or a deadline can be extended, but you really don't want to walk into that at the beginning of a case if you can avoid it. So that's my advice on it. Allison,
I
what
would
do you
agree
think?
with all of that. I think, Chris mentioned general counsel. It doesn't matter the size of your business. If you're getting a threat of a lawsuit or have been served with a demand letter from another attorney or from the court, it's going to be in your best interest to get it over to an attorney to review and to definitely make sure that none of those deadlines are missed.
Very agreed. Having an attorney to give you any kind of legal advice, especially if you're in trouble, definitely the safest and best way to go. Our next question is about Social Security. So if I am on Social Security and I inherit property from a family member here in Alabama, will their Social Security be affected?
So doing Social Security, I keep going first on this, Allison, and I'm sorry for that. I keep jumping in. For those of you at home who do not know, Allison is far more frightening than I am, and that is an absolutely true statement. She's amazing. But to answer the SSI question here is, when you're dealing with inheritance of property, you need to understand the difference between SSDI and SSI, okay? SSDI, or Social Security Disability Income, is based on you having paid in from jobs that you have worked over time. You've probably seen it on your pay stubs where you're paying into the federal government for Social Security benefits. a social security tax. That doesn't really matter what property you inherit. It doesn't really matter what you get from family or from elsewhere. That really only has to do with whether or not you are capable of working. Now, it's a very general statement, but that pretty much applies across the board when you're dealing with SSDI, okay? So if you're on SSDI and you inherit property, not a problem, because basically what you're getting is insurance payments for you no longer being able to work for being permanently disabled. SSI is an entirely different matter. So SSI is supplemental income, okay? And so what that means is not based on whether or not you've ever worked, but it has far more limits on it. And one of those limits is you are not allowed to have at any point in time more than $2,000 worth of assets. Now, there are a few exclusions, sometimes the place where you live. So again, it doesn't necessarily knock you out of getting your SSI payments, but you're going to need to talk to the Social Security Administration, also known as the SSA, about what you're getting, where it is coming from, what you're going to do with it, because there are a few exclusions like the car that you own so that you can get to your doctor's appointments and go where you need to go. They're not going to count that as an asset against you. Usually the place in which you live will not be counted against you because, again, so if you inherit a house and let's say you're living in, you know, some type of apartment or some other type of rental and you inherit that, sometimes, and most of the time, you will be able to, you know, take that house, live in it, and that can be seen as an exclusion in most instances. But if you're talking about, you know, inheritance of money, of rare items, of basically anything that is going to increase your asset value above that $2,000 threshold, what'll happen is they will stop payments until that asset is exhausted, okay? Where you have to be extremely careful, and excuse me, where you have to be extremely careful in this kind of a situation is when you are dealing with overpayment. Okay, and so sometimes what will happen is you may inherit something. I've actually handled cases exactly like this, where you have someone gets an inheritance and they're like, well, they report it to Social Security and then they keep getting their check and they think, oh, it's okay, it's not a problem. And then 2 years down the road, they've been reviewed on this and they find out they owe, you know, $24,000 worth of back pay or whatever it happens to be. There are ways to work that though. You know, a lot of times there are payment plans. A lot of times they are willing to work with you because you are in fact disabled. It is not a case killer to inherit property, okay? But you need to do it the right way. You need to be aware of the risks. And one of those is that just because they keep paying you doesn't mean you're all in the clear. They have a certain amount of time to be able to go back and review these things, okay? And if that happens, it's okay, you can talk to them. A lot of times you can request a waiver, meaning, you know, you're saying, hey, I'm disabled, I didn't know this was a problem. There are a lot of avenues and they have to tell you about them, so you can call them and ask, okay? So again, forearm yourself with knowledge whenever dealing with the legal world. Yeah.
I do. One of the ways to avoid that actually occurring is come talk to a lawyer. We have a lot of ways to maybe get around that inheritance coming into your income level. One of the ways that we can do that is we can create what's called a special needs trust. Basically, we can include it, put that inheritance, whether it be a house, whether it be money, whatever it is. We can potentially put it in a special needs trust, which will allow you to still receive, income supplement, but also or any government benefits really, but still allow you to use that inheritance for other purposes, such as entertainment or going to get more clothes, anything like that. So just come talk to a lawyer and we'll be able to see if we can, avoid any of the overpayment.
Hello, and welcome to Legal Minute with Bennett Driggers of Johnston, Moore, and Weston. Today's topic, Contractors.
Good afternoon, this is Attorney Bennett Driggers. Today I want to talk to you about contractors and hiring contractors for the work you may need around your home. Contract litigation is one of the big areas that we practice in our law firm. And one of the reasons is people don't do their homework first. First, you want to verify that you're dealing with a licensed contractor and that they have insurance. Ask for those documents. They should be willing to show them to you. Ask about their experience and their references. Do your own research on their reputation in the community. Get detailed estimates and transparent pricing. And make sure you get a clear project timeline. Communication and professionalism is key. Make sure you review the contract and payment terms, and by all means, don't pay a large lump sum up front. This is a red flag. Most of all, protect yourself. If you have questions, have an attorney review your contract ahead of time. Thank you.
Well, guys, we do have a follow-up question on this topic. So how would someone in Alabama go about applying for Social Security disability? And do we have any kind of time frame of what that process would look like? And when would they need to involve an attorney in this process?
Oh, another Social Security question. I was really hoping you were going to be able to field the next one, Allison. I've been talking this entire time. Okay, so when it comes to that, you go down and you can apply. Well, you can apply online through the Social Security Administration. It's the SSA. And when you do so, they will ask you a series of questions. They'll ask for some documentation, your doctors, your medications, what you believe is making you ill or what your disability is, and you can fill it out online. You can also go down to the Social Security office, the SSA office here in Madison County. It's down off Wind Drive. And I usually recommend that. I always recommend doing it in person in case you have any questions. You can also come to an attorney to fill it out. But realistically, it's a very simple packet. So unless you are dealing or have a family member dealing with some form of mental health issue or cognitive disability, which does happen, a lot of times it's best just to fill out that application yourself. That is something where it is very straightforward and relatively easy to understand. As far as timing and getting a decision is unknown. And the reason I say unknown is because ethically, lawyers are not allowed to give a time frame on things like this because we're not in control of it. But I've seen it happen relatively quick, usually about 60 days, give or take, to get your initial approval or denial. Now, going through the appeals process or getting reconsideration can take significantly longer. So the entire process, depending on whether or not you are initially approved or not, can take anywhere between 60 days to about 18 months.
Okay. Well, thank you guys for advising us on the process to go ahead and get that started. We know a lot of elderly people really appreciate this advice and helping them how to navigate helping them navigate how to handle their income when they're either disabled or no longer able to work. So I really appreciate you guys helping us on that. And thank you guys for tuning in to our North Alabama Law Review tonight. We always appreciate you tuning in to us. And if you have any questions that you want to have answered on air, you can send them to our email at legalhelp@jmmtlawfirm.com.